This is a Supreme Court case under the Burger Court, New York Times Company versus the United States. The United States and Vietnam have had relations since before 1945, as they wanted to, together as Indochina, wanted to eliminate the power of Japan within Southeast Asia during World War II. The predecessor of the CIA, the OSS, had relations with Ho Chi Minh as well and supported his effort for independence against France. But their unity would be short-lived following the death of Franklin Roosevelt, the 36th president, as his number one foreign policy objective was to eliminate Japan. 3 administrations later, including an escalation under President Kennedy and the domino theory in full swing, they saw, the government, that there was a specter haunting Southeast Asia. In Vietnam, North Vietnam that is, and the Viet Cong were seen as number one priorities. Firstly, in them supporting South Vietnam and Diem, but then fully committing in the cloudy circumstances of the Gulf and Tonkin incident, which allowed the top general at the time, General Westmoreland, to send troops in a conscription, the draft, to Vietnam. With little progress made, the military in Vietnam saw it as necessary to boost the morale of troops. And General Westmoreland had a motto that there was light at the end of the tunnel for his boys. However, numerous negative media portrayals of the war led to great disdain to America's involvement. There also grew a credibility gap with how much the people are willing to trust the government. The Pentagon Papers were being written as a narrative of all involvement in Vietnam from 1945 to 1967, prior to the Tet Offensive. Daniel Ellsberg, an employee at the Rand Corporation, one of the companies that helped to create these files, decided to do photocopies of a majority of the volumes and sent it to the New York Times due to what he saw as a systematic dishonesty by the Nixon administration, by the Johnson and Nixon administration. The reasons for the continuation of the war were listed in a pie graph that were the following: 70% to avoid a humiliating U.S. defeat, a morale crusher to both the military and to the country as a whole at the Cold War. Institutionally, in Congress, Senator Mike Gravel of Alaska decided to submit his volumes that were given by Ellsberg to his subcommittee's congressional record. Nixon was originally resistant to prevent the publication of the papers due to the bad portrayals of his previous presidents, both ideological enemies. However, he later urged his Attorney General John N. Mitchell, who was also associated with Watergate, to pursue a case against the New York Times and Daniel Ellsberg. The Times would appeal the case all the way up to the Supreme Court, in which the New York Times and their counsel were the petitioners. Attorney General Mitchell's strategy was to use prior constraint in totally preventing the publication of the papers rather than doing so after the fact. He would use the 1917 Espionage Act, Section 793, to do so. Prior constraint was the executive's ability to prevent the release of any articles that would have been seen as harmful by asking the judiciary to do so. What was determined to be harmful was used by Justice Oliver Wendell Holmes, Jr., as a clear and present danger, as the case Schenck v. U.S. The defendant of the case, Nixon's Solicitor General Irwin Griswold, said that the harm was a grave and immediate danger to the security of the United States. The New York Times counsel included Floyd Abrams, who was a constitutional law legendary expert who specialized in the First Amendment, and focusing on freedom of the press, that being the lens of Congress shall make no law abridging the freedom of the press. Also on counsel was Alexander Bickel, the plaintiff advocate, the one who would be arguing the case, and he worked with Abrams to break down Section 793 of the Espionage Act. They planned on pursuing 3 different arguments pertaining to that section. The first being that the section was too broad. It was all-encompassing wording that didn't specify the situation of use, encompassing everything from a code book, a sketch, a photograph, an appliance that it can even relate to national defense. Second was the precedent that was used for this act and how it was, in that typically it was used as in criminal proceedings rather than what the New York Times and the US are going through, which is a civil proceeding. This is where our good friend Holmes also agrees. And lastly, would be a more future looking to the broad argument that this precedent that it would set for the use of prior constraint in the future would constrict the freedoms of the First Amendment and thereby putting prior consent in prior primacy over the First Amendment. This case was also alongside argued with the United States versus Washington Post Company et al., in which the defendant, William Glendon, asserted that when you bring a case, you are supposed to prove it. And when you come in claiming irreparable injury, particularly in the area of First Amendment, you have a very, very heavy burden. This would be used later. So this is the question. Was the Nixon administration infringing on the New York Times First Amendment right to freedom of the press by seeking to censor the release of government materials, that being the Pentagon Papers? In a word, yes. In a 6-3 decision, the court sided with the Times that it did indeed violate the First Amendment right to the freedom of the press and freedom of the speech. The court's opinion, or the per curiam opinion, would now establish this new rule that allows prior constraint to be used in these circumstances, and applying the words of our good friend Glendon, that the heavy burden of showing justification for the enforcement that had not met due to, quote, any prior constraint on expression comes from this court on a heavy presumption against its constitutional validity. And in other words, that there was immediate doubt that the government could ever use prior constraint, and that it is not the publisher who bears the burden, but is the one who seeks to control information, and that the First Amendment was always supreme. And at this point in the war, it was also deemed that there was no clear and present danger to the troops. The rule set by, the test set by Schenck v. U.S. The concurring opinions by the individual justices, Black and Douglas, Hugo Black and William O. Douglas, concurred with the court's opinion that security must not be a word that is used to infringe on the fundamental right of the First Amendment. And in their opinion, quote, the word security is a broad, vague generality whose contours should not be invoked to abrogate the fundamental law embodied in the First Amendment. Both very committed civil libertarians believe the First Amendment as the most supreme. William Brennan, on the same block as Black and Douglas, was absolutist in his positions on the First Amendment, and he went about it a different way, that being that they failed to show that, in the words of Griswold, that there was a grave and immediate danger to the security of the United States, to those soldiers overseas, and using Neer v. Minnesota as a test as to whether or not he would yield censoring powers to the executive, the government failed to pass even one of these exceptions. Number 1, a danger to the military. Number 2, a danger to decency. Or number 3, a danger to the citizenry. And from his opinion, quote, thus only governmental allegation and proof that publication must inevitably, directly, and immediately cause the occurrence of an event kindred to imperiling the safety of the transport already at sea can support even the issuance of an interim restraining order. Ultimate quipping that the government is not yet presented or even alleged that publication of items from or based upon the material at issue would cause the happening of an event of that nature later being that it would set in motion a nuclear holocaust. Byron Whizzer White and Potter Stewart, more of the moderate members of the Supreme Court. They were both skeptical about the events preceding the case, them being Ellsberg and such, and they supported the effort that the Nixon team did to protect, in their words. But even they admit, quote, "But I cannot say that any disclosure of any of them, the documents, will surely result in direct, immediate, and irreparable damage to our nation or its people." The defense failed to bring or prove that there were papers that would put in danger. And these were the swing votes that swung it in favor of the New York Times. Justice Marshall, Thurgood Marshall, agreed more or less with what Black and Douglas said, that the words national security lend themselves to exploitation during wartime situations. He also argued that it shouldn't be the Supreme Court that establishes laws, rather they would leave it up to Congress to establish those laws of judicial constraint. It is not up to the court to decide when. The dissent included Chief Justice Warren Burger, John Harlan, and Harry Blackmun. They did not argue that they had evidence the U.S. that would put the lives of men in peril, and they didn't argue on the Neer versus Minnesota test that they crossed any of the three thresholds. What Burger argued, and in which Harlan and Blackmun joined, was that the process was hasty, and given the extended length of the Pentagon Papers with many, many volumes, that there should have been a dedicated period which to fully understand the implications of these releases. The aftermath of this decision was that the freedom of the press and the First Amendment at large were medically freed, metaphorically, of the government's use of prior constraint most of the time. This is especially true with the print media, in which the government had little power in how it could, or what it could censor before publication. Now, from the per curiam opinion, the new rule, heavy burden of showing justification for the enforcement of such prior restraint. In other words, any system of prior restraints of expression comes from this court bearing a heavy presumption against its constitutional validity. This landmark decision led to most cases, even regarding security matters, that the court will typically side with the publisher rather than the censorer, or the one attempting to censor the government. One example was the release of the Afghan War Diary and the war in Afghanistan, and its authenticity is confirmed by most news outlets. The reaction from the Pentagon Papers generally in their release from the New York Times was drastic implications on policy making, on the court makeup later, and voting realignments from the New Deal to now. Thank you.